Companies Act. One is the Securities and Exchange Board of India, the SEBI, and the other is the stock exchange, in which a company proposes to do its listing of securities. So these three statutory agencies or authorities must get a copy of the prospectus so that they can browse through it and suggest any modifications or improvements or omissions which the company may have overlooked. And only once you get a green signal from the three agencies, it must be from all the three agencies, the company can actually go public. So you have a date for the prospectus, you file a copy of the prospectus with the three agencies. 3, you appoint the issue management team, which will also include making a newspaper advertisement in 3 languages, 1 in English, a prominent newspaper having circulation across the country, 1 in Hindi, and 1 in the local language of the place where the registered office of the company is situated. By doing all this, the statutory authorities and the general public become aware that this company, XYZ Limited, is opening up its public issue. I told you the best way to understand these provisions, or for that matter anything, is to imagine it. So now let us say we are the company. It's a public listed company. We have appointed the issue management team. We have supplied a copy of our prospectus to each of them. And now we are ready. Once the newspaper advertisement comes out, let us say today morning in the newspapers, today morning will be taken as the date when the issue has opened. So people come to know it through newspaper advertisements. Newspaper advertisements is the bare minimum requirement that the Companies Act has provided. There are public limited companies which go one step further, making advertisements on internet, on the radio, on television, only to enlarge the reach to the people about the public issue of capital. So today, as of now, the position is advertisement has been made, statutory authorities have approved it, people are going through the prospectus offer document. They can approach any of the issue management team, which will be specified in the issue opening advertisements. If you go back and see the different types of prospectus, we had come across one of them, which was the information memorandum, the abridged prospectus. These are all short forms of the prospectus. The issue opening advertisement will have a copy of the prospectus in a very abridged form, in a very, diminished form, containing only the basic contents for people to know. And that advertisement or that notice accompanying advertisement will give a direction asking investors to refer to the main offer documents before taking an investment call. So the issue opening advertisement will have a brief idea about who are the stock market intermediaries facilitating this company in the task of raising money from the public by way of issue of securities. So the adequate information necessary to start is there in that abridged prospectus or the information memorandum. So people start going to the bank, which is appointed as the underwriter, which is appointed as a lead manager, which is appointed as the banker to the issue, and start making applications. They will take the application form and the prospectus, supply their basic KYC details, pay the application money, take a copy of the receipt and the prospectus, and go back home and sit and wait for the allotment to be done. So in brief, the procedure so far is to have a date for the prospectus, then comes filing of the prospectus, then it is the appointment of the issue management team, which includes or basically called opening the issue. We have crossed up to this, and now we come to the minimum subscription. So after the issue has opened, people have started applying. Money starts trickling into the bank account. The company cannot proceed with the next step unless this major hurdle is crossed, called minimum subscription. I remember having given you a title or a caption to what it is. We have just mentioned that minimum subscription is the amount which is either initiated by the promoters in the prospectus or statutorily fixed under law as the minimum required to commence commercial operations if it's a new company going in for an IPO. If it is an existing company making a further public offer, they might be raising these funds in connection with an expansion program or a diversification program. So for that diversification, or in the case of a new company for the commencement of commercial production, what is the minimum that the promoters expect to raise out of this public issue is called the minimum subscription. That is the meaning. Now, statutorily, minimum subscription has been fixed under law. For example, if a company is making an issue of capital, the proceeds of which are going to be worth 1 crore. On the one side, the promoters feel that a basic minimum is required. Apart from that, statutorily, under the Companies Act, under the SEBI ICDR regulations, what should be the minimum that the company must raise is prescribed. So promoters form an opinion about the minimum subscription, and the law prescribes for a minimum subscription. You have to reconcile between the two. So after having understood what is minimum subscription, let us set about prescribing it. So I think that is where we have stopped. The minimum subscription means or refers to the amount prescribed by the promoters in the prospectus as the minimum necessary to be raised by the company in order to commence commercial operations or in order to facilitate or feed that expansion or diversification program. Which means that unless that minimum is received, the company cannot go in for the next step, which is allotment of shares. Application for shares is naturally followed by allotment of shares or securities, debentures, bonds, etc. Although I am using the word shares as a common noun, it applies to all securities which are used by a company as a fundraising, capital raising mechanism. So we have given the meaning of it, we have given the definition of minimum subscription. Now we come to how much is it? And I asked this question and you gave me the answer of 90%. I'll just polish that 90% now. 90% is the minimum subscription. And that is fixed under the SEBI regulations, the SEBI ICDR regulations. Anyway, so I hope you are able to imagine it now. Please stand at this level. where the minimum subscription has to be raised or received by the company from the public. Now, let us technically define it as per statute. What is it? What is it as proposed by the directors? We have seen. What is it that is statutorily prescribed? Let us come to the technicalities of minimum subscription. Minimum subscription means, or the amount to be raised as the minimum subscription according to the ICDR regulations refers to the application money in respect of not less than 90% of the number of shares issued to the public via this prospectus. I repeat, what does the SEBI ICDR say? The issue of capital disclosure requirements regulation says minimum subscription means the application money, if you have staggered it into application money, allotment money, first call money, second call money, and so on. What is the amount payable by the subscribers to the shares as the application money in respect of at least 90% of the number of shares issued to the public for subscription. So the 90% actually refers to quantitative number. It is not 90% of the issue size. So SEBI says the minimum subscription raisable, which must be raised by a company on a public issue of capital, is 90% of the number of shares for which the application money is received. Let's take a very simple example. A company is making an issue through a prospectus of 10,000 shares of rupees 10 each. I'm keeping it exaggeratedly simple. 10,000 shares of rupees 10 each at par, which is payable as rupees 6 on application, rupees 2 on allotment, and rupees 2 on call. $10,000 shares are issued of rupees 10 each at par, for which the amount payable is fixed in the prospectus by the company as 6 rupees on application, 2 rupees on allotment, 2 rupees on call. I'm just using numbers. By the way, I hope you have your calculators ready. I told you in my class, don't avoid the calculators. Of course, not much of astronomical calculations. Now here, what is minimum subscription according to ICDR? Let us apply the principle. Let us apply the rule. 10,000 into 10 is 1 lakh. 1 lakh is called the issue size. But remember, 10 rupees is not payable immediately when you make the application. When you make the application, unless it is book building, you are experts on book building. In a book building issue or in a book building process, you can't stagger it like this. The system or the scheme itself is such that the entire amount has to be paid with application. So I am referring to a fixed price issue or a conventional or orthodox issue. The application money payable is 6 rupees per share. So if I am going to apply for out of these 10,000 shares, 500 shares, what do I have to pay as application money? 6 into 500. Right? So when you say minimum subscription is application money, in respect of 90% of the shares issued, number of shares issued is 10,000. So the total issue size would be 10,000 into 10, which is 1 lakh. But what would be the minimum subscription? 10,000 into 90% into 6. Definitely, it can't be 90% of 1 lakh because the application money payable is only 6 rupees. When the application money is payable, application money payable is 6 rupees only, you have to apply 6 rupees on 90% of the number of shares issued. So 10,000 into 90% is 9,000 into 6, which is 54,000. So here, minimum subscription according to law, according to the SEBI, is 54,000 rupees. 6 into 9,000. What does that mean? Unless this company receives 54,000 rupees on application, he can't go and allot shares. If this 54,000 is not received, something less than that is received, the company may have to abandon the issue and refund whatever is collected to the investors or the subscribers who have paid application money. So it is not 90% of the issued capital. Be a little careful there. It's a technical nuance. 90% is measured in terms of number of shares. And then you multiply the application money on that. Therefore, be very careful when you are defining or when you are quantifying. Defining minimum subscription is a minimum amount expected. But when you quantify it, be technically correct. Minimum subscription means application money in respect of at least 90% of the number of shares which are issued to the public. So it depends on what the board of directors or the promoters have fixed. Companies Act, we have already seen it. According to the Companies Act, what does the prospectus include in its contents as required under section 26 as the minimum for the company to receive, to commence commercial operations on that particular diversification or expansion program? Now, this is something I have been warning you about when we started the chapter. There are provisions that we are going to cover, which are distinctly, differently provided for by the Companies Act on the one hand and by the SEBI ICTR regulations on the other hand. And in case of a disparity like that, we would have to reconcile. And in reconciling, you may have to take the worst provision. Take the one that is stricter. Only then you will achieve what we call simultaneous compliance. So here I have to bridge the Companies Act and the SEBI ICDR and quantify what is the minimum subscription in a particular case, in a particular publication. Right? So let's write this down. You already given the meaning about. Now below that, just write it down. The ICDR regulations prescribe for the minimum subscription in a public issue as the application money in respect of not less than 90%. Application money in respect of not less than 90% of the number of shares, not less than 90% of the number of shares issued by the company through the prospectus. Issued by the company through the prospectus. Okay, so I repeat that. The SEBI ICDR regulations prescribe for the minimum subscription to be application money in respect of not less than 90% of the number of shares issued by the company through the prospectus. So we have worked it out here, I have quantified it and frozen it as 54,000 in my example here. Now, after you have understood this, now comes the problem of this simultaneous compliance. 54,000 is what you have calculated and fixed as payable. I'm just erasing the top part now to show you a controversy, to show you a disparity possible. Don't take this example now, we'll write it down a little later. I will be needing this a little later, but then before you take it down, I want to show you a problem. So in the case of a company which is now issuing 10,000 shares at rupees 10 each, payable as 6, 2 and 2. Application money we fixed as 54,000 as per the ICDR. 54,000 is quite a tall bargain. You must understand that minimum subscription is a huge roadblock. 90% is too high. Standards set are very high. You can understand the logic behind it. Forget the rule, forget the law. Look at the logic, look at the reasoning behind prescribing a minimum subscription. The idea is to ensure that a company penetrates the market only if the market accepts the company. If the application money received is in respect of less than 90%, it is a very clear indication that the public are not interested in that company. And if the public are not interested in that public company should not be allowed to go public. That's the logic behind it. 90% is a pretty high benchmark. Now, this is a public listed company which is going in for an issue after giving a copy of the prospectus to all the three statutory authorities, which means the stock exchange and the SEBI, and the registrar also have a copy of the prospectus apart from the public. And remember, promoters are pretty smart. When the promoters of a company are making a prospectus like this, they will mentally calculate it first itself. They know that in this case it is going to be 54,000. Now, what the promoters do is they will specify in the prospectus. Remember, the prospectus under the contents, section 26. One content is the minimum amount required to commence commercial operations. Now, that minimum required, which is included in the prospectus, need not be according to SEBI. What is it that they feel? Now, imagine in this case, the promoters in the prospectus, they mention that the minimum subscription is 40,000. In the prospectus, it is put there as 40,000 is enough to start commercial operations. So now I have a problem. Minimum subscription as prescribed in the Companies Act, that is, as put in the prospectus, and as is prescribed by this ICDR. What is prescribed here is 40,000, and what is calculated here is 54,000. You see the problem? Now, what will be the minimum from 40,000 or 54,000? This is why I said, whenever there's a conflict, you have to follow the stricter of the two provisions. When SEBI says minimum is 54,000 and Companies Act says minimum is 40,000, naturally the minimum will become 54,000. So 54,000 will operate in this case as a minimum subscription, which means it is whichever is higher. This is the dictum. That is the law. Companies Act defines minimum subscription in one fashion. ICDR defines minimum subscription in another fashion. Which one is tougher in the case of a company issuing a prospectus for raising capital will have to be followed. So in this case, it is 54,000, ignoring 40,000, because this is a more stringent provision. And believe me, in most cases, this is what will be more stringent. So ignoring the fact that the directors feel that only 40,000 is necessary, unless 54,000 is received, this company cannot go for that. That is the importance of being, or the importance of the provisions applicable to a public listed company. You see, there are 2-3 cases like this we're going to have problems. This is the first of them. There are at least 3 at your level, at the inter level, of a contradiction to be resolved or to be reconciled between the Companies Act and the SEBI prescriptions. Okay, so now, how does your notes look? You have mentioned first the definition, which is nothing but the minimum subscription prescribed under the Companies Act. Secondly, you have written or you have mentioned the prescription of minimum subscription as per the SEBI. Now write it below that in the next line. The prescriptions of minimum subscription being different between the Companies Act, the prescriptions of minimum subscription being different between the Companies Act and the ICDR regulations, between the Companies Act and the ICDR regulations, comma, the listed company will be required to comply with the more stringent provision between the two. That is, the higher of the two, shall apply. The higher of the two shall apply. Okay? So this is the case of a listed company which has to comply with both the Companies Act and the ICDR. So in other words, it is whichever is higher. There are so many things that you learn from this. The promoters need not calculate the minimum subscription as per the SEBI and put it in the prospectus. What they feel arbitrarily, it's a guess. What is it that you feel necessary? For capital assets, I need so much. For incorporation, I need so much. To repay my subscribers the memorandum, I need so much. For drafting documents, I need so much. So all in all together, I need 40,000. You can say that. So this 40,000 has been determined by the promoter very arbitrarily. Of course, it may not be that arbitrary. They may have actually calculated the expenditure under various heads and decided that is 40,000. So between 40,000 and 54,000, 54,000 is higher. So in this case, the minimum subscription is 54,000. Not even considering this 40,000. So in short, it will be that which is higher. Right? Now, again, I need not repeat this, but I'm doing it for you to understand it. This is the case of a listed company. If it's a private company, or if it's an unlisted public company which is not going to the public with its share capital issue, this thing will not apply. Whatever is prescribed in the Companies Act, whatever may be prescribed in the company's rules, only that will apply to a private placement of capital made by a private company or an unlisted public company. So we have prescribed it under the Companies Act, we have prescribed it under the ICDR, and we have reconciled them also. And I also gave the logic behind why is a minimum subscription of such and such an amount prescribed. Okay, now take down this as an example, but in a more polished manner. Take this down with the numbers. We'll explain this. Okay, so take it as an example, as a problem. I'm giving it as an example problem. Okay, example: XYZ Limited. XYZ Limited. Our parent is a public company, private. Private and I use the word XYZ private limited. This is one method by which the institute confuses you in exams, in questions. Questions are very, very precise. They are razor sharp. XYZ Limited, this is a public company. You can assume that they must have missed the word private, the private company, assuming that is a private company. So XYZ Limited issues a prospectus. For the issue of 10,000 equity shares. 10,000 equity shares of rupees 10 each. Of rupees 10 each, payable as follows. Payable as follows. Okay, 1. On application, rupees 6 per share. On application, rupees 6 per share. 2. On allotment, rupees 2 per share. And 3 on call. On call, rupees 2 per share. On call, rupees 2 per share. Okay, XYZ Limited issues a prospectus for the issue of 10,000 equity shares of rupees 10 each, payable as follows. On application, rupees 6 per share. On allotment, rupees 2 per share. On call, rupees 2 per share. Now, below that, mention, given that the prospectus contains an amount of rupees 40,000, contains an amount of rupees 40,000 as expected minimum subscription, comma, compute the level of minimum subscription. Compute the level of minimum subscription to be complied with. Compute the level of minimum subscription to be complied with by XYZ Limited. By XYZ Limited. I wouldn't be surprised if a problem like this is given to you in the exam. Okay, so now take the answer also in my words. You know how to calculate it. One is given as 40,000. The other has to be computed as 54,000. Okay, now do one thing. You also split into two parts. Minimum Subscription Companies Act, ICDR, 40,000. And we will write this 54,000. Put that working in brackets below that. Below that, mention in brackets 10,000 into 90% into 6. And then tick the 54,000. Mentioning below that whichever is higher. So this is the minimum subscription as per minimum subscription as per Companies Act, 40,000, which is there in the prospectus. ICDR, 54,000. 10,000 into 90% into 6. That's what we have worked out. Tick this showing that this is the minimum subscription, and then mention the next line. Therefore, in this case, the minimum subscription is rupees 54,000. Therefore, in this case, the minimum subscription is rupees 54,000. Okay, so you understand this, that whenever there's a controversy, whenever there's a disparity, incongruity between the Companies Act and the SEBI ICDR, I am sorry to say, unfortunately, you have to comply with the worst of the provisions. Only then you can be said to have complied with both. Because for a listed public company, both the Companies Act and the SEBI are applicable. Because it's a company, Companies Act. Because it is listed, SEBI. Okay, now I'm going to take you to another level from here. We have decided the prospectus says 40,000. We have calculated the minimum subscription. I remember the figures roughly, so I'm going to remove this part. Now this summarizes what we have done. So we have decided now, there's no controversy. The minimum subscription is 54,000, which is 10,000 into 90% into 6. Now I'm coming to a different possibility. Let me calculate it first. Suppose in this case, I change this. Suppose I say in the prospectus that my minimum subscription expected is 55,500. So that will become 55,500 here also. Remember, it's a case of a company which has issued 1 lakh shares of rupees 10 each, payable as 6 plus 2 plus 2. Now I have changed my figures slightly to see if you can handle the new figures. Prospectus says 55,500 is the minimum subscription. That is, the promoters say, unless we receive 55,500, we can't proceed with this issue. We cannot proceed with this project or the commencement of commercial activity. This time you have a case where Companies Act figure is higher. Minimum subscription computed applying the provisions of ICDR, 10,000 into 90% into 6 is 54,000. Whereas what the promoters feel is 55,000. If the promoters feel that anything more than 54,000 is necessary, naturally that will become the minimum subscription now. So now the balance tilts. The weighing balance tilts in favor of the Companies Act. Now the minimum subscription is 55,500. But then we have a new problem. If 55,500 is the minimum subscription, which is what is going to be effective this time, you have to work back and compute the number of shares which the public has to subscribe for. It's a very simple calculation. 55,500 divided by 6. What will that come to? 9,250. $9,250 is in terms of number of shares. In the previous case, it was 9,000 shares. So I'm building up a new block. You will have to determine minimum subscription in terms of both amount and number of shares. Here, when the minimum subscription amount is given to you, you're working backwards. Working backwards, you get the minimum subscription in terms of number of shares, which is 9,250. That means, unless the public subscribes for 9,250 shares, the company cannot go in for launch. So here, the computation is amount being given, number of shares to be determined. If minimum subscription in terms of rupees is 55,500, in terms of number of shares, it is 9,250. We have worked back, given the number 6. Clear? So you should be comfortable, you should be flexible both ways, irrespective of whether it's in terms of money or in terms of number of shares. Okay, now why don't we write this down? In the next slide, note. Suppose comma, in the case of XYZ Limited, suppose in the case of XYZ Limited, the prospectus had prescribed suppose in the case of XYZ Limited, the prospectus had prescribed minimum subscription. The prospectus had prescribed minimum subscription as rupees 55,500 as rupees 55,500, comma, the number of shares, the number of shares to be taken up by the public the number of shares to be taken up by the public will require to be worked backwards as 9,250 shares. As 9,250 shares. Okay, within brackets, 55,500 divided by 6. $55,500 divided by 6 is 9,050. Okay, so what is it that is coming to our rescue here? It is the concept of whichever is higher. Because now the minimum subscription has changed. Previously, when this was 40 and this was 54, it was 54. Now, when this is 55.5 and that is 54, 55.5 becomes the minimum subscription. That is the importance of the word minimum. When you say minimum subscription, and two minimums are prescribed under two laws, naturally you will take the higher of the two. Right? So, this is the concept of minimum subscription. Now, let us proceed with the other things. I mean, the numbers itself was a little difficult to digest. 90%, amount prescribed by the promoters, whichever is higher, working backwards in certain cases like this. So right now we have just understood what is minimum subscription and how is it prescribed under the two contradictory provisions of two different statutes. Now there are various other questions to be answered. Minimum subscription is a very, very dangerous provision. Very dangerous. And because it is dangerous, people keep picking up loopholes. So we have to plug each of these loopholes also. Now, I have got the answer to the question, what is minimum subscription? How much is it as prescribed statutorily? Now comes the next question. Can I keep waiting to get this minimum subscription? Remember, the number of applications that the company's lead manager receives, I told you, once the issue management team is deputed, is appointed, the company can relax. Company will sit back. Then everything is done by the lead manager. That's why he's called the lead manager. So people go to the lead manager, they go to the bank, take the application form, fill it up, give their KYC details, take a copy of the prospectus, a copy of the receipt, and come away. And the lead manager will go on making a statement, an Excel sheet. Who has paid how much on what day, how many shares. So shareholders or the investors only pay, go, pay, go, pay, go. So this happens over a period of time. Now, as I told you, minimum subscription is a pretty high benchmark. 90% is quite high, you will agree with me. A company which is relatively new in the market, a company which is coming up with an IPO, may not be able to judge the market that well, however professional you are. So what you fix in the prospectus, what is it computed as per the ICDR, how do you reconcile them, is a big task for them. They need professionals like you. Now, the next question is, within what time should the company get this minimum? As I took an example. Let us say the issue is opened today. Today is the 15th of May. I lost track of time. Sometimes it becomes very difficult. What is today's date? What is today's date? They come to such a situation. Let us say it is open, the issue is opened today. 15 May 2020, bank opens at 10 o'clock. So technically speaking, perfectly speaking, the issue has opened on 15th of May 2020 at 10 a.m. The minimum subscription of 90% is prescribed. Don't you think there should be a prescription form? Within what time this must be obtained? Remember, things don't happen overnight. When a company has issued a prospectus for 10,000 shares, applications for those 10,000 shares will keep coming in installments. Let us say at the end of today, 300 shares the company has received applications for. Tomorrow, another 450 shares. So totally you have received application for 750 shares. On the third day, another 2,000 shares. 2007. So this happens over a period of time. How long do you think you can give a company to raise this minimum subscription? Again, we have a controversy. The Companies Act says that the issue can be kept open for 15 days. In other words, within these 15 days, the minimum subscription shall have been raised. 15 ദിവസം, 2 weeks, a fortnight. Comfortable, very nice. So this is what will apply to unlisted companies. You know what ICDR says? ICDR says the issue can be kept open for 10 working days. Today happens to be a Friday. One Sunday is coming. The next Sunday will also come in that gap, in that band. So according to the ICDR, 10 working days, which might effectively come to 12 days. 2 Sundays are going to intervene. So what would normally have been 14th of May will become 16th of May. But according to the Companies Act, 19, the issue has to close. So this is the subscription period. The subscription period is prescribed as 15 days under the Companies Act and 10 working days under the SEBI. I have my same problem. How do I reconcile? Suppose there are a lot of holidays coming. in between national holidays, of course, then this might go beyond 15 also, because you're talking of only 10 effective working days. Companies Act doesn't use the word working. 15 days. So here, what would you say? Whichever is higher or whichever is lower, 15 days or 10 working days, whichever is lower. Look at the difference. Minimum subscription is the minimum which is to be raised. Subscription period is the maximum period for which it can be kept open. So when you say an issue can be kept open for a maximum of A days, B days, naturally it will be the lesser of it. So in most of the cases, again, ICDR decides and not the companies. Generally, the 10 working days such a short would be definitely less than 15 days. Follow? No, I can't give the company eternity to raise minimum subscription, to advertise, to make its market, to coax people to subscribe to its shares. So the maximum period prescribed is 10 working days or 15 days, whichever is less. In the previous case of minimum subscription, I said whichever is higher. And I hope you understand the difference and why the difference. Minimum of A and B. Naturally, it has to be the higher of it. Maximum of A and B. It has to naturally be the lower of it. So after deciding what is minimum subscription, how much is it, now I have entered within what time you must raise it. Okay, now we are coming to various other aspects of minimum subscription. There are plenty of aspects about minimum subscription, of which this is the first. So after whatever you've written so far, now give us some heading. What shall be some heading as? Provisions relating to minimum subscription. Give us some heading. Provisions relating to minimum subscription. Provisions relating to minimum subscription are things, legal provisions about minimum subscription after you have understood what it is. Okay, so provisions relating to minimum subscription. That's a subheading. Now below that, 1. The prescribed minimum subscription applicable to the company shall be obtained or raised, R-A-I-S-E-D, shall be obtained or raised within, hyphen A, 15 days, hyphen, as per the Companies Act 2013. 15 days as per the Companies Act 2013. and B, 10 working days. 10 working days. Hyphen, as per the ICDR guidelines. As per the ICDR guidelines. Okay, full stop. In the next line, therefore, the subscription period, it's technically called subscription period. Therefore, the subscription period shall be the higher, shall be the lesser, right? That's what we decided. Yes. Shall be the lesser of the two. Therefore, the subscription period shall be the lesser of the two. That is whichever is lower. Shall be the lesser of the two. Okay. So what is minimum subscription? In terms of meaning, in terms of quantity, and even for quantity in terms of amount, in terms of number of shares. How do you reconcile the Companies Act with the ICDR? First question we have answered. And the second one is the subscription period. How long can an issue be open, kept open for subscription? The subscription period is 15 days of the Companies Act or 10 working days of the ICDR, effectively boiling down to whichever is less, because the period prescribed is 15 or 10 maximum. Now comes the question, what if it doesn't happen? The companies having mediocre goodwill, not very acceptable in public domain, may fall short of the 90%. Even if they wait for 25 days, 1 month, 3 months, 9 months, are 90% will get. Now, let us say it effectively works out for the 10 working days. Let us say the issue has to close. And remember, the prospectus will have to mention the closing date. You can't just leave it open. The prospectus will mention the issue opens on 15th of May 2020 and closes on 26th of May 2020. It had to be mentioned. Now, by 26th of May 2020, if this amount is not received, or if I have not been able to match up to that 90%, I've got only 50%. Application money in respect of only 50% number of shares issued has been received. Then what to do? I'm sorry to say, cancel the issue and refund the money to the investors. So whatever amount has been raised as application money, remember, where is it lying? It is with the lead manager. It is with the bankers of the issue. And the lead manager is keeping track of all this. Every day evening, the promoter in charge, let us say it's a chartered accountant, let us say I am the promoter in charge of your company, making a public issue. Every day evening, I will get a call from the bank. Today, we have received application for so many shares. We have received so much of money. Yesterday it was this, before that it was this, totally we are collecting so much. So monitoring all this, the time period, the amounts, is a responsibility of the lead manager. That's why he's been appointed. So all the money which is being received as application money over a period of time is going on getting accumulated in a bank account, which is maintained in the name of the company with the lead manager. That is why it has to be a bank or a financial institution. So even by the last date, if the amount of minimum subscription has not been raised, remember the lead manager has a list of all the investors, refund it to them. This is why they insist on having a bank account, so that the amount can be put back into that bank account by the lead manager. Now follow this carefully. The issue has opened today. The issue closes on this date. The provision is within 15 days, and here at least, thank God, Companies Act and SEBI are on the same provision. Both say 15 days. Within 15 days, it must be repaid. I am giving the company 15 days time to repay the amount from the day that the issue is closed. If you don't, after that, interest will be applicable at the rate of 15% per annum. Easy to remember. 15 days, 15%. So if I talk about the Companies Act language, issue is open for 15 days. If you have not received the minimum subscription, repay it within 15 days. If you don't do it, pay interest at the rate of 15% per annum. This is prescribed under the Act. And the SEBI agrees with the Companies Act that the interest rate should be 15%. There's no conflict there. If the minimum subscription is raised, you can go to the next stage. You can go in for lockdown. If it is not received, you have to abandon the issue. You have to tap the issue and refund the amounts. Okay? So write that as number 2. If the minimum subscription is not raised within the prescribed time. If the minimum subscription is not raised within the prescribed time, comma, the application money is received shall be refunded by the company. The application money received shall be refunded by the company -A, below that A, within 15 days of closing the issue. Within 15 days of closing the issue. And B, if a default is committed, and B, if a default is committed on such refund, if a default is committed on such refund, comma, subsequent refunds shall attract interest. Subsequent refunds shall attract interest at the rate of, shall attract interest at the rate of 15% per annum, 15% per annum. Subsequent refunds shall attract interest at the rate of 15% per annum. Okay, again, I'm using a lot of numbers. 15 days, 10 working days, 15%, 15 days for refund without interest. Okay, so this is the provision. If you are not able to, again, if you take it like a flow chart, issue closes, you have two routes, two options. One, you have received the minimum subscription. Two, you have not received. If you have received it, pass to the next stage. If you have not, close it down. Your issue, capital issue to the public, will be killed at that stage. And very naturally so, because it means that this public listed company does not have popularity with the public, or it has not marketed itself properly, or the company is not considered to be a company which is worth being listed on a stock exchange. Those are the various reasons because of which minimum subscription may not be raised. But that is why an underwriter is there. Now you understand underwriting better. The concept of underwriting, the arrangement of underwriting, the contract of underwriting is basically to get over this hurdle. Because if underwriting is done and you don't meet the 90% minimum subscription, the underwriters will take up the balance. So if the public has subscribed only for 72% of the number of shares, 28% of the number of shares will fall on the underwriters. We have a beautiful word for this in company law. That liability devolves. D-E-V-O-L-V-E-S. Devolve means to fall on your head. Talaki. It's a liability hanging somewhere there. On the event of not receiving it, it falls on your head. Devolvement of liability. Lovely word. I like that. So this is the basic purpose of an underwriting agreement. An agreement between a company and a set of people called the underwriters, who take up the responsibility of the liability that a capital issue to the public will be fully subscribed by the public, and in the event of failure, they will take up the shares in their names. So indirectly, the underwriters will market your capital. Right? Now, naturally, there is one thing to be understood here. The interest of 15% per annum will be attracted only if a default of payment beyond 15 days is the fault of the company. So the question of payment of interest, where there is a delay beyond the 15th day, arises only if it is out of the company's default. Mention that as 3. The interest liability on amounts to be refunded, the interest liability on the amounts to be refunded arises only when the delay in refunds, only when the delay in refunds arises, the delay in refunds arises owing to the company's default. Only when the delay in refund arises owing to the company's default. Okay, so naturally it goes without saying that if it is the investor's fault, the amount will not be paid with interest. The refund, of course, is due. But there is one particular possibility that all these amounts lie with the bank forever. I'll be dealing with the same issue in dividends also. Now, when the company cannot make the issue of capital, cannot go in for allotment, and it wants to refund, and there are some of them, they have applied for 40 shares, 15 shares, 20 shares. They won't even bother. They go home, sit and wait, maybe they might be illiterate. They sit at home and wait for allotment. No information from the company at all. Nothing has come. They are not given any means also for communication. Then it doesn't happen that refund cannot be done. So this is why it is important that the refund is delayed because of the company's default. Then only the interest at the rate of 15% per annum will be applied. Okay, so we have learned a lot of things. What is minimum subscription? How do you quantify it? Higher of the two, lower of the two. Companies Act, ICDR. And what happens if you don't receive it? Now we have 2-3 other loopholes which are applicable in this provision for minimum subscription. Shall we take it up after a break? I'll just be back. Give me 10 minutes and I'll be back. What was the note that we had stopped at? It is only if it is because of the company's default. That is the one, right? If the company makes a default, then yes, okay. If the company makes a default, then only the interest is applicable. Otherwise, there's no question of, there's no necessity for paying an interest where the investor cannot be traced. He has not given the details, etc. So the first complication is within what time the minimum subscription must be raised. Now comes the next complication where the minimum subscription is getting raised. That is, it is not fully, I told you, the receipt of application monies happens over a period of time. I'll take an example to illustrate this. With this will understand it better. I mean, the background to this is that application monies which are received by a company have to be deposited in a separate bank account. That is to say, the company will not be allowed to touch the application monies received until the minimum subscription is received. That's the basic concept. All the amounts, all the money received shall be deposited in a separate bank account in the name of the company maintained with the lead manager. This is what I said. This is the purpose of making it a bank or a financial institution only which is eligible to handle this process. So why don't you write that first? Then I will come to the complication. So that must be note number 4. Is it 3 or 4? Not no 4. Okay, 4. It is not notes. It is under that subheading. So put it as number 4. Number 4. All amounts received as application money. All amounts received. All amounts received as application money. All amounts received as application money by the lead manager all amounts received as application money by the lead manager shall be deposited and kept deposited in a separate bank account opened in the name of the company with the lead manager. Opened in the name of the company with the lead manager until the minimum subscription is received or closing of the issue. Until the minimum subscription is received or closing of the issue. When an issue is open for about, let us say 10 working days, maybe by the 5th working day itself, you receive the minimum subscription. That doesn't mean you can use it on the 6th day. That is what I mean by receiving the minimum subscription or closure of the issue. Naturally, whichever is later, but I don't want to say whichever later because minimum subscription must be received before closing the issue, or at least on that date. Now, you must be wondering why I use the word deposit and kept deposit. That's for a particular reason, for which I'll take an example. Let us say today is the 10th, when the issue opens today. Today is 12th of May. It is a Friday. 13th is Saturday. No. Where I told you, I lost track of time. സമയം ഒന്നും അറിയുന്നില്ല. 15th ആണ്. 15th Friday. 16th is a Saturday. 17th is a Sunday. So you will not get anything there. So like that it keeps going. Let us say 18th Monday, 19th Tuesday, 20th Wednesday. Now I'm just keeping track of the amounts. Let us say the minimum subscription as in my example was 54,000. Let us keep that as a benchmark. 54,000. Let us say Today, by evening, 5 o'clock, by the time the bank closes, I have received 12,000. 16, that is Saturday, by tomorrow evening, I receive another 9,000. Let us prepare a cumulative columns to see how much you have received totally. 12,000 there, 21,000 there, 17th, nothing, so 21,000. So Sunday. 18th, let us say about 11,000. So 32,000. Yeah, 32,000. It's moving. Let us say by the 20th, it has come to, let us say, 53,000. And let us say the issue is scheduled to be closed on 25th, whatever may be. About 25th I issue closing. 20th I have received 53,000. Minimum subscription is 54,000. So on 21st morning, the company calls up the bank and says, can't you see we have already touched 53,000? It's only under 54,000. By tomorrow morning, within 1 hour it will come. So please release the money. We'll start using it for our project. And the answer is no. That is the importance of the word kept deposit. അല്ലെങ്കിൽ എന്ത് ചെയ്യും? ഒരു കമ്പനി ഡെപ്പോസിറ്റ് ചെയ്യും, വിത്ഡ്രോ ചെയ്യും, ഡെപ്പോസിറ്റ് ചെയ്യുക, വിത്ഡ്രോ ചെയ്യുക. അത് പറ്റും. So there's a specific provision that all amounts which a company has raised, has received as application money in the lead manager's account must be deposited and kept deposited until the minimum subscription is received. But even if it is received, until the issue closes, you can't touch it. Imagine the consequence of this provision was not there. Let us say the next day onwards nothing comes. Public has closed the issue by itself. No more applications from 21st. And bank even wishes to cash for. Now you have to refund. Refund your cash down. So this is only to ensure that if the minimum subscription is not received, the company has adequate funds to refund the investors in the event of not raising the minimum subscription. So that's the purpose behind it. Why don't you write it as a note? Note. The reasoning behind the provision. The reasoning behind the provision is to ensure that the company will have adequate funds to repay investors, if and when minimum subscription is not received. If and when minimum subscription is not received. Okay, so in other words, this provision is meant to ensure that the company does not utilize the application money received. So the amount which is coming, little drops of water into the bank account, let it remain there. Once the issue closes, the lead manager will ensure that the minimum subscription criterion has been met and then refund it. Or refund it to the investors or give it to the company. So the lead manager will play the role of an agent on behalf of the economy to ensure that if the company is not good enough, the amount goes back to the investors. Okay, so just go back to the provision and underline the word kept deposit. It shall be deposited and kept deposited. Okay, now coming to the other loophole which is possible in the case of minimum subscription. Again, I will take an example to illustrate this. It's a very cunning loophole pickable by the promoters. Let me explain with an example, going back to the same example that I had taken. 10,000 shares at 10 each, payable as 6, 2 and 2. This had worked out to 54,000 as per the SEBI ICDR, and here 40,000 as per the prospectus issued by the company. This 54,000 was nothing but 10,000 into 90% into 6. That is how we had got this 54,000. Okay, now there is a smart loophole possible. Some of you might have even got that idea. As a promoter, I ask the question, okay, this 54,000 is too high because my application money is 6 rupees. What will happen if I reduce that? Now I will restructure this call. Instead of 6, 2, 2, I will make it 1, 1, 8. Smart. Now look at how this affects your minimum subscription. How do you take this? 10,000 into 90% into 1. It will come to 9,000 rupees. Naturally, this 40,000 is there. We don't mind it. 9,000 or 40,000, whichever is higher, 40,000. That's easy to get. Smart. A company or the promoters of a company are trying to downgrade or bring down the minimum subscription by reducing the application. So what happens? Shareholders or the investors fall into a trap. They feel, today if you give 1 rupee, that's enough. This 8 rupees is paid only 6 or 7 months later. Good, attractive offer. So what the company is trying to do is to give the investors an idea that they have a lot of time to pay. Don't you think this is a good loophole? By doing this, you can coolly escape from the 54,000. Or it's a good idea to think that Reduce the application money, your minimum subscription will fall. Now, I have to prevent this report. Including unknown. All this has been anticipated. The drafters are pretty smart. They know that people will do this now. Therefore, there's a restriction on the application money, and you must be knowing that. When capital is issued, when a prospectus is issued to raise capital, and you are going to stage the amount in application, allotment, call, etc., there is a minimum which is prescribed for the application money, for the call money. And as far as company law is concerned, we don't make a distinction between allotment money and call money. Everything together is called call money. Because you call it up and they pay. Even allotment money technically is call money. Because you're calling and just paying. Now, the Companies Act restriction doesn't actually achieve this purpose. You know what the Companies Act says? Companies Act says the application money shall not be less than 5% of the face value. That will not achieve the purpose here. Suppose it is exactly 5% to satisfy that requirement. Application money should not be less than 5%. So if I give you 5% of 10 rupees, 5% of 10 rupees is what? 50 paise. Not even 1 rupee, 50 paise 100 pounds. I don't think your generation wouldn't have seen 50 paise. 50 paisa. 8 ana, 25 paisa. Have you seen it? 10% of 10 rupees is 1 rupee. 5% is 50 paise. So 10,000 into 90%, 9,000 into 50, 4,500 rupees. But there's a catch. The Act says the amount on call should not exceed 25% of issue price. That's the catch. It's a way of indirectly putting it the other way around. So now, what happens is I suppose I take the same thing, I don't want to disturb that. 10 rupees, look at this satisfies the condition. What you have to do is, if you are going to stage it in application, allotment and call, you have to fix up these two first because of this condition. Call should not exceed 25% issue price. 25% of 10 rupees is 250. Maximum I can fix is 250 and 250. So this provision is complemented by this. SEBI ICDR is much better. SEBI says application money should be not less than 25% of issue price. Naturally, then this will apply. The same problem, conflict problem between Companies Act and ICDR. So now, what you have to do is to fix up the call money first. Allotment money should not be more than 25%. Call money should not be more than 25%. So even if I take a maximum 250, this will become 5, which means 50% has to be raised. So individually, this provision looks pretty weak, but that is supplemented by this provision. So this is another loop. I told you, minimum subscriptions are pain in the neck. Promoters, directors normally try to avoid this or tackle it. These are the methods they have identified. Taking away the money from the bank, without keeping it deposited, fixing application money very low. So all these loopholes have been anticipated and provisions have been made. Now, when I say application money should not be less than 5%, call money should not exceed 25%. I know some of you are thinking even more notoriously. Itra lesser personal. I will make 6 calls, 7 calls. Application money, allotment money, call 1, call 2, call 3, call 4, call 5, call 6, call 7. Keeping each of them as 25%. Then application money will go down. But then there's another catch. One issue of share capital must be completely closed within 12 months. Get it? All the money receivable, application, allotment, calls and arrears. The issue of capital in respect of money received must be completed within 12 months of opening the issue. Number one. Number two, the gap between 2 calls should not be less than 3 months. So after allotment, I have to leave a gap of at least 3 months for the call. If you make it in 2 calls, 3 months after that. And remember, the whole thing must be over in 12 months. So we are cornering it from all the sides, all the 4 sides, and ensuring that this company manages to get the minimum subscription, and otherwise it goes out of the market. So there are plenty of conditions here with respect to the time gap between calls, minimum application money, maximum call money, Companies Act says it, ICDR says it. All that has to be read together. And as a chartered accountant, you will be required to advise how a company should call up. And all these things must be taken into account. The best thing is call up the entire thing with application, just like book building. In book building, all this doesn't apply. The entire thing is payable with application. So when you say application money should be not less than 5%, call money should not be more than 25%. If the entire amount is payable with application, do you think this condition is satisfied? Definitely. Application money should be at least 5%. This is 100%. Wonderful. Call money should not be more than 25%. This is 0. When the entire amount is payable with application. Because if you say no, that means book building will become illegal. The book building can't be illegal. It's an innovative system. Ideally, as a chartered accountant or a company secretary, I would advise a company to raise the entire amount in one shot. But if you're not doing it, if it is a traditional, orthodox method other than book building, then these conditions will have to be followed. So in short, promoters or directors cannot tamper with the application money only with the objective of reducing the minimum supply. So there is a limit to the application money. The others are not very relevant at your level, but application money, ICDR and Companies Act, the other conflict. This is the third area where we are coming to the conflict. One was minimum subscription 90%. Second was subscription period. And the third is this. How much can a company fix as the amount payable on application as the minimum? Remember, it's the minimum which is prescribed. Okay, so come to this as number 5. Number 5. The amount fixed as payable. The amount fixed as payable on application the amount fixed as payable on application within brackets there, application money. Application money, close brackets. The amount fixed as payable on application. In other words, application money, close brackets, shall not be less than okay, again hyphen A, shall not be less than hyphen A, 5% of the face value, 5% of the face value, hyphen Companies Act. Or B, 25% of issue price. Issue price is always face value plus premium. B, 25% of issue price. Hyphen ICDR regulation. ICDR regulation. Okay, now hereafter I will not tell you whichever is higher, whichever is lower. Apply your common sense. Apply your second floor and decide. So here when I say 5% of face value or 25% of issue price, you must decide whichever is higher. Because you are prescribing a minimum application money. Okay, so by fixing it like this, that loophole can be avoided. Of promoters who try to understate as much as possible the application money and escape from the provisions of minimums of the. Now that can't be done. Okay, so I prescribed there 5% of face value, which is again very, very small. That will not achieve this purpose. But the Companies Act has boldly left it at that, because SEBI will take care of it for listed companies. And the other provision has been laid out for the call money. Okay, in the next line, don't put it as 6, just put it in the next line. Similarly, comma, the amount fixed as payable on a call within brackets there, including allotment money. Shall not exceed 25%. Shall not exceed 25% of the issue price. Shall not exceed 25% of the issue price. Okay, so I'm keeping quiet there. What does that mean? That's only a Companies Act provision. There's no parallel provision in the ICDR. In other words, ICDR does not interfere with call money. ICDR interferes only with application money. I'm fixing that at a very high benchmark. Okay, so Minimum subscription conditions, provisions applicable to minimum subscription. Number one, it must be raised within 10 working days as per SEBI or 15 days as per the Companies Act. Number two, the amount which is received shall be deposited and kept deposited in a separate bank account until minimum subscription is received or the issue is closed. The third, loophole closing provision. Subscription money, application money should not be less than 5% as the case may be. Call money should not exceed 25% of the issue price. So all this is with respect to minimum subscription. You can see how dangerous the provision is. All the others are fine. I can appoint an issue management team. I can submit a copy of my prospectus to the statutory authority. They can suggest anything. I can bring about the changes. I don't mind making a newspaper advertisement. But when this condition is put, it becomes difficult for low quality companies, new companies, companies in certain specified sectors or industries to match up to that requirement. That requirement is very strict. It's a very, very strict provision that the SEBI has laid down, prescribing minimum subscription to be 90%. Okay, so I've been using a lot of numbers today. Now, this is about the minimum subscription stage which has been crossed. So let's revise. Number one, dating of the prospectus. Number two, filing of the prospectus. Number three, opening of the issue. Opening of the issue comprises appointment of lead manager, appointment of intermediaries, making issue opening advertisement. After that, the company will sit back, relax, and wait to raise the minimum subscription. Remember, if at any of these stages it's a negative, the company will have to pull out of the capital issue. It cannot be done, that's all. So let us assume that the company has crossed this hurdle. Minimum subscription has been raised. The next step, I suppose, is opening of subscription lists. Isn't it? Go to your order and see. Okay. Opening of subscription. Why don't we give that heading there? Opening of subscription lists. Opening of subscription lists. Opening of subscription lists. To understand opening of subscription lists, you need to understand what is subscription lists. Now, even here it is a provision basically for the blue chip companies. See, when I say 10 working days or 15 days, this is for the low quality companies. I can't find an appropriate opposite for the word blue chip. I mean companies other than Reliance, Bajaj, Infosys, Wipro, Tech Mahindra. They're all the blue chip Fortune 100 companies. Imagine Infosys is making a further public offer, keeping it open for 10 working days. Horrible. If Wipro goes in for a further public offer, let us say today, 15 May 2020, 10 a.m. By afternoon, this is oversubscribed. That's a blue chip company. 1 lakh shares, going by my simplified example, 10,000 shares at rupees 10 each. The issue is open today morning. by 2 o'clock, 3 o'clock p.m. afternoon, the company would have received application for 60,000, 70,000 shares. What will happen if I keep it open for 10 working days, you can imagine. Such companies would like to finish off quickly. Open the issue today, close it tomorrow. Can you do that? In other words, when you prescribe a maximum subscription period, then the next question arises, should I fix a minimum? If so, what should it be? Ten working days or 15 days, whichever is less, is an understandable provision. But 10 days is also pretty high for the excellent companies. Can we allow them to make allotment tomorrow? Imagine a company issuing a prospectus which says, issue opens on 15/5/2020 and closes by 15/5/2020. They're very confident that this is going to be oversubscribed. You issue a prospectus like that and you don't get even the minimum subscription, your fault, your problem. But can you do that? Shouldn't there be a minimum? If you ask me, I would say no, there should not be a minimum. A company which opens the issue on 15th morning should be allowed to close it on that day. But Companies Act says no, don't be so optimistic. Companies Act says we should prescribe a minimum. And the minimum prescribed is 3 working days. Now I'm talking the exact opposite nature of companies. Now I'm talking about the best companies. Indirectly, the Companies Act or the SEBI, both of them agree on this one particular topic. They say every company making a public issue of capital should keep the issue open at least for 3 days, 3 working days. The 4th day morning is technically called opening of subscription lists. That's a technical name for the morning of the 4th day. Why? Why should even that minimum of 3 be prescribed? And something interesting there. I hope you get the difference now. 10 working days maximum. Minimum 3 working days. In my opinion, and you will agree with me, such a minimum need not be prescribed. This minimum of 3 working days is prescribed for people who want to back out of the contracts. India is a country where mob mentality is very high, herd mentality. I don't know if you remember it, but I remember there used to be an advertisement for some higher education portal giving students plenty of opportunity to visualize the different courses, curriculums, colleges, universities available for their further studies. It was an advertisement for that, and then they showed one boy who says, I have decided I'm going to this college, this university, and all the others follow behind him, making the sound of a sheep. You remember that ad? That ad brings out a very important human psychological concept called herd mentality, mob mentality. It is very natural, you'll agree with me. Suppose there's a queue in front of a shop. A person passing by won't even inquire what is the queue for, he will also go and stand there. Everything free at India is a country where free ആയിട്ട് കിട്ടാനുള്ള ബ്ലേഡ് കിട്ടും, മണ്ണെണ്ണയും കുടിക്കും. So there's a queue in front of a shop. God knows what it is, that queue will get bigger and bigger. A person will first go and stand with you and then ask the person what and no more. That has hurt me. That could happen for a company's application. The lead manager of the bank, there's a queue for applications. Everybody goes and joins it. And 2 days later they realize, I didn't want this. And if this time is not given, and the company makes allotment, you're stuck. You're stuck with the contract. So that 3 days effectively gives you something like an exit option, an escape route. Within those 3 days, after having made an application, if you're not happy, if you want to back out of it, go to the lead manager, give back the receipt, take your money. In my opinion, that window should not be open. If you have gone and stood in a queue because others are standing, you want to cancel, you should not be allowed to cancel. What do you say? You agree? So this is to avoid that. We are giving them that escape. There might be, what do you call it, dummies. There might be guinea pigs. There might be those with that sheep mentality, herd mentality, mob mentality. Keep them that route, let them do if they want. This 3 days is for that. So, no company shall open its subscription lists until 3 working days have expired after opening the issue. And believe me, all the companies that I have seen at least, all the companies making a public issue, advertising in the newspaper, give exactly these 3 days. 3 working days. So it was already, so it was open today. 15th morning it was open. 15, 16, 18th evening. The prospectus will clearly mention 18th evening this issue process. Nowadays everybody fears over subscription, not under subscription. Companies are doing pretty well nowadays with a very, very few percentage of exceptions. So it's interesting to see that the minimum is fixed and the maximum is also fixed. Or the other way around, the maximum is fixed. Now we will start a minimum period also, which is 3 working days. So the morning of the 4th day is technically called opening of subscription lists. Remember, the lead manager has made a list of all the subscriptions or the subscribers. He is going to open that list. It is going to open that list. Which means for 3 days, don't touch that list. Let the money keep coming. You keep making the list. In other words, what am I trying to say? No company shall make an allotment of shares until the expiry of 3 days, including the date on which the issue is opened. An issue always opens at the start of banking hours on the day when the newspaper advertisement appears. English, Hindi, local language. So that is what we mean by opening of subscription lists, a provision which is exclusively meant for the best first-class companies. 10 working days is meant for the worst-class companies, the third-class companies. 3 working days is for the best, the first-class companies. Okay, so mention that next. In your step, you'll be numbering these steps. The next number in sequence, opening of subscription lists. No company shall proceed to make an allotment of securities. No company shall proceed to make an allotment of securities for which applications are received, for which applications are received, comma, until the expiry of, until the expiry of 3 working days, until the expiry of 3 working days, including the day of opening the issue. Including the day of opening the issue. Including the day of opening the issue. Okay, full stop. In the next slide, the morning of the 4th day, the morning of the 4th day, the morning of the 4th day of opening the issue, is technically called opening of subscription lists. Opening of subscription lists. Opening of subscription lists where the company analyzes the list of subscribers, as a preparatory step, to allotment of securities. As a preparatory step to allotment of securities. Okay, so that is the next step in the issue of capital, which is actually meant for the big companies, the very popular companies, or the, companies which have established an excellent market image or a brand value for themselves. Asking them not to hurry up and wait for at least 3 days so that you give an escape route. I hope you are able to understand. If this provision is not there, allotment of share capital will happen. And once the allotment is done, the contract falls in place. We are coming to this a little later. Issue of a prospectus is an invitation to offer. In your contract act language, Making an application based on that is the offer. Allotment of the shares by the company is the acceptance of the offer. അപ്പോൾ അലോട്ട് ചെയ്ത് കഴിഞ്ഞാൽ ആ കോൺട്രാക്ടിന്റെ ബുക്ക് വിടും. It falls in place. It's like the cage closing. Now difficult to come out. So we are giving them that one particular leeway. That leeway. If you want to back out of the contract, back out in these 3 days. That's what in that 3 minutes. So the object of this provision on opening of subscription lists is to leave the investors with an avenue without having to take a legal course of action to back out of the contract if they want. So in those 3 days, the lead manager will accept your application back. I mean, can take back your receipt and give you the application money. And accordingly, the adjustments in the book entries will be made. Okay, why don't we make a note of that also in the next line? Note the purpose behind the provision. The purpose behind the provision is to ensure that the purpose behind the provision is to ensure that the investors are left with an option. The investors are left with an option to cancel, the transaction or contract, to cancel the transaction or contract without requiring to take a legal course of action. Without requiring to take a legal course of action. I've been telling you, once you understand the logic behind the provision, you not only understand it, you start appreciating it. And that will be embedded in your memory forever. So this is the reason behind it, because if this provision is not there, the contract is going to fall in place like a fixture if the gate closes. And once the gate closes, you have to take a legal course of action. If the investor realizes there's something wrong, for example, the prospectus is misleading, there's some kind of a misrepresentation, something which is relevant has been omitted, and you have to take a long drawn legal battle. Now you can do it quickly if that back out window is open for 3 days. So opening of subscription lists is as simple as that. Giving the company 3 days time. Do not proceed further. So once you open the issue, no action can be taken at least until 3 days pass, and maximum within 10 working days or 15 days as per the company's act. So you must be able to understand the band. If this is the date of opening the issue, now I'm putting a band off. Let us say we talk completely from SEBI's point of view. You have 10 working days as the outer band, and here this is 3 working days. So nothing can happen earlier than this. Nothing can happen later than this, except refunds, allotment, etc. So the issue has to close on this date. After opening it on this date, keeping that window of 3 days open, only after 3 days something can happen. And the issue closes here, by which time the minimum subscription must have been received. If it is not received, you know the consequences. So this is about the opening of subscription lists. Now, the next in line is another simple step. Actually speaking, now taking all these into account, I can proceed with allotment. My next step is allotment. I'll open the subscription list. Let us say I pass this also. I wait for 5 days. 5 working days are waiting. Anything in between these two is ideal. So I waited for about 5 working days. Minimum subscription has come. In fact, it's an over subscription. That prescribed 3 working days is over also. So strictly speaking, I can proceed with allotment. There's nothing stopping me from doing it. But the company that says, wait, 1 minute. Please give us a copy of your prospectus once again. A very simple procedure. Whenever you have this condition, all the conditions satisfied, there's still that one step left. And this is completely company's at point of view. 5 working days have passed. I'm going to make my first allotment of share cap. I'm going to start allotment. Just like application money. Application money keeps coming over a period of time. Nothing happens overnight. Similarly, allotment also takes time. One day I allot 200 shares. Next day I allot another 225 shares. Then it's about 300 shares. So even that happens over a period of time. It is not completed in one day. However short or small your issue size is. So before you take up the first allotment of share capital or the first allotment of shares or securities, please refile a copy of the prospectus to the registrar. Then only proceed with allotment. And I remember in some context before I explained the logic behind it also. It is only to ensure that you give the registrar a facility to cross-verify. Let us say 1 or 1.5 months before you had submitted a copy of the prospectus. As a registrar, there is not much of a, facility to ensure whether the same prospectus has reached the public. So to allow the registrar such an avenue, such a facility, there's a requirement that whatever prospectus you had filed before was fantastic. There were no modifications or suggestions or amendments prescribed or suggested. You had issued it to the public. Now, before making your first allotment, do give a copy of your prospectus once again. Then you can start with allotment. So it's a very simple procedural step. It's only a ritual. I mean, in my personal opinion, this step or this prescription is not going to achieve its objective. A company can do one thing very easily. Keep 2 prospectuses aside for the registrar and issue all the others to the public. So registrar will never know that the prospectus which has reached the public is not the prospectus which is being filed with it. I don't expect the registrar or the SEBI or the stock exchange to go to the open market and see whether it is the same prospectus which has been issued. This is one method whereby legally they have an option of seeing whether it is the same thing. So it is only a very small clerical administrative ritual which will not achieve the parliamentary objective behind the provision. So just mention that last. It's a very small step, take it down in one line. The next step, refiling a copy of the prospectus. Refiling a copy of the prospectus. Okay? A public company shall refile a copy of its prospectus. A company shall refile a copy of its prospectus with the registrar. So this is the companies are provision only. With the registrar before the first allotment. Before the first allotment of securities. Before the first allotment of securities. Okay, full stop. This procedure is only a facility for the registrar, to ensure, is only a facility for the registrar to ensure that the prospectus issued to the public, is the same. The prospectus issued to the public is the same as the copy of the prospectus first filed. Or in other words, it is to ensure that the prospectus which has reached the public, is the same as was approved, by the three statutory authorities is the same as was approved by the three statutory authorities. Now, who are these three statutory authorities? The registrar, the SEBI, and the stock exchange, where the company has listed or proposed to list. Okay, so this gives an option. This gives the registrar a consolation. It gives him the relief that the same prospectus which was filed with him has been issued to the public. What has reached the public is not a new prospectus. Okay, now the next is allotment, and with allotment the procedure ends. But before I come to allotment, there is one very frequently asked question in the examination which I wanted to prepare for. There is a company which has made an application for listing on 3 stock exchanges. Okay, I'm going back to the initial stage, before the allotment, minimum subscription, etc. A company has made an application for listing on 3 stock exchanges. The company has received an approval for listing only from 2 of them. One stock exchange has not given an approval. Can the company proceed with the publication? And the answer is no. It is important that the company must get a listing approval. It is called an IPA. IPA means in principle approval. That means a provisional approval at least. So it is necessary that the company must have got an approval from all the stock exchanges where it has proposed listing. So even if one of them does not approve of it, it is not permissible for the company to proceed. Okay, so just make a note of that. And we'll wind up with that for now and continue in the next class. Note, where a company has applied for listing, where a company has applied for listing of its securities, listing of its securities on 2 or more stock exchanges, on 2 or more stock exchanges, comma, approval must have been obtained. Approval must have been obtained from all such exchanges. Approval must have been obtained from all such exchanges in order to proceed with the public issue. In order to proceed with the public issue. And therefore, if approval is not obtained, from even one stock exchange, approval is not obtained even from one stock exchange, comma, the company shall not proceed. The company shall not proceed with the public issue. The company shall not proceed with the public issue. Right, so fantastic. With that, we'll conclude the session. We'll continue in our next session, which is scheduled for, I think, the 19th or so, 19th and 20th or so. I think the timetable has been sent to you. So we'll wind up now, continue the next session. Thank you.